December 21st, 1988, 7:03 in the evening. It is Pan Am Flight 103, 40 minutes out of London, bound for New York. She is cruising at 31,000 feet, crossing the Scottish border in the dark. On board are 243 passengers and 16 crew. The aircraft is a jumbo jet. Her name is Clipper, mate of the seas. Then the sky opens. A bomb is hidden inside a cassette player, packed into a suitcase. It tears the plane apart in seconds. The wreckage falls across 845 square miles of Scottish countryside. It lands hardest on a small town called Lockerbie. 270 people die that night, 259 of them in the air, 11 more on the ground. In their own homes, it is still the deadliest terrorist attack ever committed on British soil. And 38 years later, the case is still not closed. Pan Am 103 was a routine transatlantic run, the kind of flight where nobody expects to become a headline. The passenger list read like any December crossing: American students flying home from a semester abroad in Europe, business travelers, families, military personnel, and British Christmas travelers. The bomb was checked as unaccompanied baggage. It was routed through Frankfurt and then through London before it ever reached the aircraft. That one fact would define the entire investigation to come. When it detonated, the forward cargo hold failed first. The nose of the aircraft separated from the fuselage in roughly 3 seconds. What followed was not one crash site. It was many. Sections of the plane and everything inside it came down across miles of Scottish countryside. In Lockerbie itself, a wing section struck a street called Sherwood Crescent. 11 residents died there. One of the 270 was a woman named Flora Swire. She was 23 years old, a medical student, flying to New York to spend Christmas with her boyfriend. Her father is a British doctor named Jim Swire. He would spend the next 4 decades as one of the most visible faces of the family seeking answers. Nearly every hearing, every appeal, every anniversary, he became the most persistent and most publicly documented campaigner this case produced. He is not the only one, but across almost 40 years of coverage, his is the name that keeps recurring. The investigation matched the scale of the crime. It became one of the largest criminal inquiries in British history. It reached into more than 50 countries, and it ran for years before it produced a single trial. Investigators worked the wreckage field for months. They rebuilt pieces of the aircraft by hand, trying to trace the blast back to its source. The breakthrough was very small, a fragment of circuit board, barely the size of a fingernail. It was later designated PT-35B. Forensic analysis matched that fragment to a specific model of timer. The timer was made by a Swiss company called Mebo, and Mebo, investigators concluded, had sold it to Libya. That fragment became the spine of the entire case. It pointed toward 2 Libyan intelligence officers. The first was Abdelbaset al-Megrahi. The second was his co-accused, Al-Amin Khalifa Fima. What happened next had no precedent. Scotland and the Netherlands agreed to convene a Scottish court on neutral ground. The venue was a former U.S. Air Force base called Camp Zeist. It meant the 2 men could be tried under Scots law without ever being extradited to Scotland. The trial ran for roughly 9 months. The prosecution's case rested on 3 things. First, the PT-35B fragment. Second, evidence placing Megrahi in Malta, buying clothing that was later found in the bomb suitcase. Third, a Maltese shopkeeper named Tony Gauci. Gauci identified Megrahi as the man who bought it. In January 2001, the court convicted Megrahi. It acquitted Fima. Megrahi was sentenced to life imprisonment. At the time, it was the longest minimum term a Scottish court had ever imposed. He always denied it. By 2009, he was suffering from terminal prostate cancer. That year, he was released from a Scottish prison on compassionate grounds, and he returned to Libya. There was a condition attached to that release. He had to abandon his first appeal. He died in Libya in 2012, still maintaining his innocence. For 19 years, Abdelbaset al-Megrahi was the only person ever convicted for the deaths of 270 people. Here is what makes Lockerbie unlike almost any other terrorism conviction in British legal history. The doubt around it is not fringe speculation. It is documented. It is litigated. And as recently as 2021, it was argued in open court. In 2007, an independent body called the Scottish Criminal Cases Review Commission finished a 4-year review of the case. The commission exists to look for miscarriages of justice. It referred Lockerbie back to the appeal court, citing multiple grounds for concern. Among those grounds were 2 questions. How reliable was Tony Gauci's identification of Megrahi, really? And had the defense been given everything it was entitled to see before trial? That appeal never reached a verdict. Megrahi abandoned it in 2009 to accept compassionate release. The question did not go away. In 2020, the commission referred the case a second time. Megrahi's family pursued a posthumous appeal. More than a decade after his death, a court would finally rule on the doubts the commission had raised. On January 15, 2021, a 5-judge bench of Scotland's High Court of Justiciary delivered that ruling. The court rejected the appeal. On Tony Gauci, the judges wrote that his credibility had not been challenged during the trial. They pointed to other evidence as corroboration: al-Megrahi's presence in Malta under false documents, links to the purchase of the bomb's timer, and on the material the defense had never seen. The judges were just as direct. In their words, it would have made no difference to the verdict. The conviction stands. It has now survived 2 reviews by an independent commission and a second appeal pursued after his death. That is the legal fact, and it is an important one. No court has ever found al-Megrahi innocent. But something else is also true. The questions an official review body raised were serious enough to produce 2 separate appeal proceedings, 8 and 20 years after the original verdict. And campaigners, Jim Swire among them, have argued for decades that the wrong man may have carried the greater share of the blame. Both of those things are part of the documented record. Neither one erases the other. In December 2020, the U.S. Department of Justice unsealed charges against a third man. It was the same year the Megrahi case was quietly reopened in Scotland. The third man is Abu Aguila Mohammed Massoud. According to the DOJ, he spent decades as a Libyan intelligence operative, and his specialty was technical. He built explosive devices. Massoud had already been in Libyan custody for years. He was arrested in the chaos that followed the fall of Gaddafi in 2011. In December 2022, he was extradited to the United States. In 2023, he pleaded not guilty. The government's case leans on something that happened 8 years before those charges were filed. In 2012, Massoud allegedly gave a statement to Libyan authorities. In it, he admitted to building the bomb. It was not a video. It was a written account, documented by a Libyan police officer. That statement is now the prosecution's central piece of evidence. There was supposed to be a recording of it. For years, according to defense filings, a video of that 2012 session sat in a safe in Libya. In 2024, Libyan officials were asked to hand it over to U.S. authorities. It could not be produced. According to the defense, it is lost or destroyed. Massoud's attorneys argued that the recording mattered enormously. In their words, it was the only thing that could have shown signs of stress, pressure, or coercion not reflected in written statements. Massoud himself has claimed the 2012 confession was coerced. To be clear, that is his defense's claim, made in court filings. It is not something this video is asserting as fact. And here is the turn. The video was gone. So was the original handwritten statement, and so was its carbon copy. Authorities in Tripoli reported they could not locate any of it. In August 2026, the trial judge ruled that the confession could be used anyway. Prosecutors argued the detail in it was corroboration enough. A fabricated confession, in their telling, would be unlikely to contain what this one does. And the Libyan officer who documented the statement is expected to testify in person, so a jury can weigh his account directly. No recording, no original document, a confession the defense says was coerced, and a judge who decided the jury should hear it anyway. As of this video, jury selection is expected to begin the week of August 24, 2026. The case is called the United States versus Abu Aguila Massoud. It will be heard in a federal courtroom in Washington, D.C., 38 years after Pan Am 103 came down over Lockerbie. Finding 12 jurors who do not already know this story may be a challenge of its own. The case has been covered, dramatized, and documented for decades. The most recent telling is a Netflix series that premiered just weeks before this trial begins. Proposed jury instructions reportedly include a warning judges have rarely had to give before. Don't check the prediction markets. Whatever the jury decides, it will not undo the questions this case has carried since 1988. It will not reopen the appeal Scotland's courts already closed in January 2021. It will not bring back the recording that vanished from a safe in Libya. And it will not change one more thing. For 38 years, one family after another has kept showing up, to hearings, to anniversaries, to appeals, waiting for a version of the story that finally holds together. 270 people died on December 21st, 1981. One conviction has stood for 25 years, contested but unbroken. A second man is finally headed to trial, and the recording that might have settled the loudest remaining question in this case no longer exists. Jury selection starts in days. We'll be watching.